Good afternoon. This is Marsha Waters, the Director of Doors Division of Real Estate. Today is April 22nd, 2024, and the time is 2 p.m. I will now call the meeting to order. Before I call roll, I would like to advise the task force and members of the public that while the Division of Real Estate has been tasked with leading this task force and ultimately the issuance of the task force's report, the views, opinions, and recommendations discussed and expressed by this task force are not the views, opinions, or recommendations of the Division of Real Estate or the Department of Regulatory Agencies. I will now call roll. Joe McConnell, Dr. Davis, Natasha O'Flaherty,
Present.
Brian Matisse,
Present.
Bert Nadler,
Present.
Barry Wilson, Representative Parenti, Senator Gonzalez, Marianne McGeady. I can see your screen. Jennifer Tanaka.
Here.
And Steve Odorizio. Well, we do have a quorum, and Sarah, I will turn it over to you.
Fantastic. Thank you, Marsha. I'm just going to go ahead and get our slideshow going. Well, good afternoon. Good to see you all. It's been 2 months since our last task force meeting, so nice to see many familiar faces joining us this afternoon. So just a quick overview of our agenda for today. We basically have two primary items that we are going to be covering this 1 hour meeting that we have together. The primary purpose of this final meeting is to review the HOA task force final report, which this task force is specifically required to do per our enabling legislation. So we will be spending the majority of our time on that topic today. And since we haven't seen you in a couple months, and this is our final gathering of the task force, we thought it would be a nice opportunity to just recap for a few minutes at the end of our meeting to provide just an overview of what we've accomplished together throughout this process. We're also going to provide a summary of the feedback that we received from many of you on the interim Metro District Task Force report. So we'll have an opportunity to talk about that when we do our recap at the end of this agenda. So before we move on to our HOA task force report review, are there any questions on the agenda? Marvelous, great. Well, as you know, House Bill 1105 provided for the creation of two task forces, one that was focused on issues pertaining to HOAs and a second that was focused on issues pertaining to metro districts. This legislation was highly prescriptive, with both task forces given specific topics they must address. In addition, our Metro District Task Force had one additional mandate in the legislation, and that was to review the HOA Task Force final report. And specifically, the legislation states the following, and bear with me, I'm going to just quote this here. As part of the task force's examination, the task force shall review the recommendations and report of the HOA Homeowners Rights Task Force to determine whether the findings and conclusions set forth in the recommendations and report apply to and provide guidance for the task force's own findings and conclusions regarding issues confronting Metropolitan District homeowners' rights. So the HOA report, our task force actually did not have to review anything from us, but we did have to review this final report from the HOA task force. So as you know, the report was released on April 15th, which was last Monday, and it was provided to this task force as a pre-read along with our agenda last week. Now, the HOA report has 10 defined topics that were itemized in the enabling legislation and discussed at various points over the course of their 8 meetings. And so given our limited time today, we're not going to go and review each of these sections of the report one by one, but instead we are going to organize our conversation around 3 primary questions. So the first question that I will ask you is, are there any topics or findings in the HOA report that the task force members believe are exclusive only to HOAs and thus not applicable to metro districts? That'll be your first question. The second question I'll ask is, are there any topics or findings that task force members believe may have some application or impact on metro districts? And then at the end of our conversation, I'll ask my final question, which is, are there any general observations or themes in the HOA report that are relevant to our work as a task force or otherwise worth noting for the record? So I've got the 10 sections that are listed here on the slide to help us organize our conversation and also just make sure that we're not missing anything as we go through our discussion. For those of you who might have the report from the HOA task force printed off, I do have some page references that I can give you if you want to flip to certain pages and be able to skim some of this content. You're welcome to do so throughout our conversation. So we will begin with our conversation around what we think is really specific to the HOAs that are not relevant at all to metro districts based on the 10 items that you see here. And again, actually, before we get into that, I want to just clarify for space considerations, there's a couple of these that I did abbreviate. So just for clarity, our first section is around finding authority and practices. Then we have a section on foreclosure practices. And then the one that I have, number 3, that's listed as just communications, that is the expanded version of that is communications with HOA homeowners regarding association processes and HOA homeowners' rights and responsibilities. Our fourth section is also a long one. So it is the availability of and method of making available to HOA homeowners in the association, the governing documents, policies, rules and regulations, financial statements, the most recent reserve study, and any records of the executive board's actions related to collections activity or legal action taken against a unit owner. And that's number 4 that I tried to collapse as much as I could. Then we have HOA homeowner complaints, the examination of HB 221139, creation of a reserve bill, creation of ADR or alternative dispute resolution, licensure of community association managers, and a voter reform bill. So I did have to collapse some of those section headings for space here, but those are the sections that we're going to be discussing today. So the first question, back to that first question, is, are there any pieces within these 10 that you feel were very, very specific to HOAs and really did not have any application to metro districts? Yes, Jennifer, go right ahead.
Sorry, I was waiting for somebody else to kick it off. I see Brian and I kind of tied for raising our hands at the same time. I think a lot of these are really hard because they are an apples and orange situation. You're talking about finding authority and practices, they're just different. And so when you have the HOA task force addressing some of those concerns, it's just not an apples to apples scenario. So in my view, there are small snippets of some of these which are applicable to districts as well, and certainly those that provide covenant enforcement design review. Just for if it works well, for me, I would say number 1, finding authority and practices is pretty specific to Title 32 and not an apples to apples in many regard, other than when it comes to covenant enforcement design review type of actions. Foreclosure practices, I feel like this was just addressed in Representative Judah's bill that was just signed by the governor on Friday. Specific, since we're talking about kind of HOA overlap items, I think that was handled. Communications, we have Senate bills 262 and 190 that really addressed communications with those that are purchasing new homes as well as resales, that I feel is kind of preemptively address the issues that the HOA is trying to address here. Governance finance records, our records are open to the public. This to me is not applicable at all, since their records are under different statutes. Homeowner complaints, the same kind of, and the examination of 1132 are the same, that I don't feel that those are applicable. I would say the licensure maybe for those that provide covenant enforcement and design review, to the extent that the same type of scope overlaps, that there could be some overlap there. And I don't think voter reform bill applies either, because we are subject to different statutory requirements when it comes to voters and how those are conducted versus an HOA. So those are my thoughts.
Excellent. Thank you, Jennifer. Brian, please go ahead.
Ones that I see that have no applicability are actually, I think, pretty limited. First of all, I think the reserve study does not apply because metro districts have completely different methods of financing. You don't really need reserves for metro districts because we have broader taxing and fee authority. Secondly, I don't think 221139 applies to metro districts, so I don't see that there's any applicability there. That's really completely separate from that. Similarly, I think the voter reform, because metro districts have their own election code, the local government election code, that doesn't apply as well. Now, I think I disagree a little bit with some of what Ms. Tanaka just said. I think that although, for example, metro district governance and disclosure requirements are different because of statute from HOA disclosure requirements. For example, metro districts have to post certain items on their website that HOAs don't. They have to maintain a website. They have to post certain documents on DOLA, et cetera. I think it is worth discussing whether some of the items that the HOA task force requests, particularly with regard to financial disclosures, should be made more transparent and more available to metro districts. For example, metro district website requirements are actually fairly limited as to what is absolutely necessary. And there's a lot of financial disclosures that, although they may have to be filed on the DOLA website, or they may have to be filed with the Office of the State Auditor, ordinary individuals in these communities don't necessarily know where to look. They're not necessarily required to be in a plain form on a metro district website, and I think there should be a more user-friendly form. As I've mentioned many times, I'm very much in favor of, as I say, Truth in Lending Act type black box requirements that can fit on one page that clearly express the financial positions of metro districts. I think it would be worthwhile to have similar transparency with regard to some of the HOA disclosures on their financing to metro districts. It should be made in a clear form to homeowners so that they understand exactly what they're going to be responsible for and exactly how well their metro district is doing financially and perhaps comparison to others. So I think that although they're a little different, I think I would not exclude those completely. Similarly, with regard to homeowner complaints, although metro districts are government entities and they're not under DORA with regard to any kind of receiving of homeowner complaints, I think the requirements or the proposals are similar, and we do need some kind of a repository at a minimum, some kind of a government entity that at least can be an ombudsman or at least a repository of these complaints to perhaps look into those. And so I think those should still be considered relevant for metro districts. And I'll let someone else have the floor.
Great, thank you, Brian. Other comments from folks on the call? And again, we're focused on things that you think that are really specific to HOAs and don't have application to metro districts. We've got an initial list from Jennifer that was really thorough, and then Brian offered a couple of different perspectives on things that may have some relation to a metro district. So appreciate that, Brian. Other thoughts on this?
Hey, Sarah, I noted that it looks like Mary Ann's having some issues joining, but it said that she's on by phone. I don't see her on the side, so I just want to make sure that she's able to participate to the extent she wanted to.
Thank you, Jennifer. I know Commissioner Odoricio also was trying to get into the Zoom, so hopefully we can get the Zoom's permission set so they can actually log in.
Yeah, I think, can you hear me? This is Mary Ann.
Yes, we can hear you, Mary Ann. Hi.
Okay. Yeah, so I don't know what is going on with this computer, but I guess you got some kind of visual of a inserted photo of my office because I'm not even in my office, and
indeed,
at least the phone's working now. So I'm sorry, what I missed was most of what Brian and half of what Jennifer had to say because I was messing around trying to get in the meeting. So I apologize for that.
That is totally fine. I just posed the question to the group for that first discussion question around what are the pieces of these 10 items that really are highly specific to HOAs and don't really have any translation over to metro districts, or as Jennifer said, the apples to apples comparison just isn't there. Are there any other comments from folks on those items that really are very specific to HOAs? Okay.
I'm going through the real quickly. Sorry.
Yes, absolutely.
And again, I apologize if I'm being redundant to what has already been said. And I think I might have a different take than I think what I heard Brian say about the creation of a reserve bill. I think in looking at the history, I think what the reserve bill is requiring reserve studies to be done for maintaining the HOA's facilities so that it's clear the fees are being set not only to take care of the current costs, but also future costs for repair and replacement. Is that right? Am I understanding that, Brian, what a reserve study is about?
I mean, my understanding of reserve studies for HOAs, they are required to conduct a reserve study to determine whether the annual HOA, or I should say the monthly HOA fees are on track to be sufficient to put into reserves enough fee money each year of reserve fee money to cover the costs in the long run of replacing those items. So that's very different with metro districts because, as you know, many metro districts do not have monthly fees or they're solely paid by taxes. So, and metro districts also have the ability, if for example a repair or replacement is necessary, they have taxing ability. They have the ability to borrow funds through government bonds, which are very different from HOAs, which typically don't have that ability.
Yeah, I hear what you're saying. And actually, I don't think there is a statute that requires reserves because it's recommendation number 9 on page 35. And I'm not an HOA expert and I'm not that familiar with Kiowa, but it looks like some of the members of that task force for HOA issues was recommending creation of a reserve bill. I feel that it would be helpful for metro districts to also have a reserve study requirement, not because of setting fees, which if they have fees, it would be helpful for that. But even setting your property taxes, you need to know what the expenses are. So I hear what you're saying, Brian, not a reserve study that's like a rate study, because we're not necessarily needing a rate study for metro districts, but knowing that you have a schedule for replacing the pumps in the pool. Is it every 3 years, 5 or 7? On the playground equipment, particularly those, I'm thinking districts that have park and recreation amenities, it might be helpful for them to be required to have a reserve study so that as they're planning what their general fund property taxes will be for the next 10, 15, 20 years, they don't have surprise years. Because I agree they have the right to pop those taxes up, but I don't think anybody wants to live in that environment. But anyway, that's just a thought on that bill. So I think that bill, if the question, I'm sorry, I'm losing the question. If the question was, were there things in here that are HOA only, I might be answering the wrong question. But I did think that was something that would benefit districts. I agree with Jennifer, a lot of what's in here really isn't relevant to districts. But that was one I thought could be helpful.
Great. Terrific, Marianne, that's terrific. We are specifically talking about things that are not applicable, but I think it is just kind of a natural flow of the conversation that we're seeing, that there's some themes and other items that could translate nicely to metro districts, even if it's not specific to how it was written in the report. So I think that's still very helpful context and information. Natasha, I see your hand raised. Please go right ahead.
Just a short comment. I originally had also put the reserve as being unique to HOAs, but as I sit and listen both to Brian and to Marianne, I think it is relevant. I think what we heard very clearly from homeowners, and there should be kind of a capital budget or analysis in metro districts. I think a lot of what we heard about is, you do a road that maybe has a shelf life up in the mountains of 8 years, but you have a bond that's paying off 35 years, decades after the life of the item that was funded is gone. So in its own way, in terms of transparency, I think Marianne brought something here that is valid and needs to be included for metro districts of what are the capital requirements and replacement requirements, so that when people purchase a property, they have an understanding of, are they paying for the roads that, were built decades ago and are already being redone, or are they looking forward?
This is Marianne, and I'm sorry, now I've lost this connection as well, so I can't put my hand up. Is it okay if I say something else?
Yes, yeah, you can, Marianne. Sorry about that. It's so frustrating. It's the last meeting too, right? Everything's gone fine up until now.
Sure. Well, and yeah, my challenge is my daughter is up doing pre-op stuff with her husband. She's having a big surgery tomorrow, so I'm with the 1 and the 4 their house. So that might be my problem. Well, to answer the question specifically, what I could do is and rather than talk about the topics, because that could take a long time, I could go through what's in the report, the item numbers, because each page has item numbers on it, and say the ones that the numbers of the items described that don't apply. Is that helpful?
That I think we could go section by section. Yeah, and actually what I can do is summarize what has already been brought up, and then maybe Marianne, you can add, and anyone else can add comment to that. So what I've heard so far, and I may have missed something, so please folks, don't be shy to jump right in, is that item number 1 around finding authority and practices was very specific to HOAs and how it's organized under Title 32. I also heard that foreclosure practices, which is that second section, also highly specific to HOAs and specific rules that govern HOAs versus metro districts, not an apples to apples. Item number 3, I heard initially maybe that was around communications with homeowners regarding processes and rights and responsibilities, highly specific to HOAs. But I do want to just pause there. Is that section around communication something that people think should perhaps be moved over to the may have application, or there's some potential application?
Sarah, this is Jen. I just to back up on the foreclosure practices, I don't think, I just want to clarify what I said, that we have a new bill from Representative Judah that was signed by the governor, which I think addresses concerns that were raised in that report. So I didn't want to suggest that wasn't applicable. So I want to clarify that.
Thank you.
Communications, similarly, we have 2 bills that were enacted in 2023 and 2021, which addressed the same concerns that are being brought up by the HOA in that section of it, that I think in large part address those concerns. There may be, if I'm understanding from Brian's comments, some other areas that we need to focus on, but that was what I was noting for the communication section.
Thank you. I appreciate that, because if I misnoted it, then it's possible. I want to make sure we have it correct in the record. So I appreciate that. All right. So on our third section around communications, what I had heard initially is that was, again, pretty specific to HOAs, not necessarily applicable to Metro District. Did anyone disagree with that? Brian, yes, please go ahead.
Well, I guess I'm confused as to this whole process here, because there are definitely items in the communications section that apply to both metro districts and HOAs in terms of their recommendations. Now, it is true, metro districts and HOAs, I'm concerned that today this whole process is all messed up. It wasn't what I was expecting. And what we're going to be doing is going back and forth over things instead of either going item by item, or instead of having each person just comment on the report as in general. But the bottom line is there are items. I mean, I've flagged items in every single area that apply and don't apply. So I don't think we're going to get anywhere close to getting done in an hour if we're going this route of back and forth like this. That's just my thought. But there are definitely items in the section on communications that are applicable here to metro districts in terms of what we need to be communicating, and we're not doing a good job communicating, even though we have different statutes.
Brian, well said. I appreciate that. And I appreciate the visual aid of your sticky notes. Very helpful. When we set up this process, we weren't really sure if all of these items require discussion. So we were going through this process was designed with the idea of if there's some things that don't require conversation, we'll just set those aside. But it sounds like there's a lot more detail baked into this than perhaps we realized. So with that in mind, certainly happy to go item by item just to ensure that we are getting everything. So happy to adapt on the fly, not a problem at all. So going back to before we're at number 3, which is communications, but under finding authority and practices, was there any additional comments that people wanted to make about that section? Brian, I see your hand raised again. Please go ahead.
Yeah. I just want to, there is something that is important for us to understand and for the people of Colorado to understand. Finding authority for metro districts derives from 2 distinct sources. One is their general finding authority as a government entity under section 32-1-1001-1J. And that says that the metro district as a government entity has the ability to impose fees, fines, tolls, etc. for its facilities. For example, damage to a public property. That is something that they have general ability to fine under as a government entity, just like any other kind of government entity. And it's very broad. On the other hand, those metro districts that enforce covenants, they have a separate source of fining authority, and that's fining authority pursuant to the terms of the covenant, which is similar to an HOA's fining authority. And I think that to the extent that the metro district is essentially being nothing more than an enforcer of the covenants, which I have problems with independently of that as to whether government entities should be enforcing private covenants that private individuals set up. But taking that aside, if the authority is based on enforcing the covenants and the fining authority under those covenants, that needs to be precisely the same as the limitations that HOAs have under those covenants, because they derive from private covenants and not from the inherent power of metro districts as government entities. So that needs to be very clear up front, I think.
Great. Thank you, Brian. Does anyone else have comments around finding authority and practices that was documented in the HOA report? Okay. So we'll move on to the foreclosure practices. We had a little bit of conversation around that, but would like to open that up to specific comments around the section on foreclosure practices. And actually, I'll help you out. That starts on page 11 in the report. Were there any notes that folks wanted to share about reflecting on this and where there is some applicability to metro districts based on what the HOA report says around foreclosure practices? Yes, Brian, go right ahead.
Sorry for dominating, but I'm not hearing a lot of people commenting, so I wanted to express this. All right, in terms of foreclosure practices, metro districts typically don't have the same problems as HOAs have in collecting revenues in the forms of either unpaid fees or unpaid taxes. Unpaid taxes, of course, that source of revenue, there's no problem at all because that's collected through the county treasurer. Similarly, metro districts rarely have to go through the entire foreclosure process because of the fact that their fee lien is superior to the first deed of trust and unlimited. And therefore, ordinarily, just a simple notice by the metro district to the first deed of trust holder, the bank or whatever that holds it, is sufficient to encourage full payment. And then the bank or whatever takes whatever action is necessary against the homeowner to make sure that that gets added to the mortgage or whatever. On the other hand, HOAs are very different. HOAs, their foreclosure practices, because they're typically inferior to the first deed of trust, with the exception of a 6-month super lien, which is very limited compared to the first deed of trust. They have serious problems. And often they'll go through a foreclosure and and the HOA's lien will get largely wiped out except for the super lien, and they'll lose a lot of money. So there's a lot more risk there. So I think some of the problems that that are applicable to the foreclosure process and some of the high costs of the foreclosure process for HOAs, which causes some heartburn on the fact of both the homeowners and the legislators. We don't see as much of that with Metro District. We rarely have to go through the entire foreclosure process. So that's a distinct difference, I think.
Great. Thank you, Brian. Natasha, I see your hand raised. Please go ahead.
I was just going to make the comment, though, that I think we heard very loudly and clearly from the public, and I think in our discussion about foreclosure practices in the realm of metro districts, that it seemed like in the discussions both with this panel and the public is that we wanted to make sure that the same consumer protections were in place, and that they would run somewhat parallel, especially as Brian pointed out, that a metro district is in such a superior financing position. And it was really new to me when I joined this task force to see how much covenant enforcement of these private covenants metro districts are taking on. So I think we want to be very sensitive and very cognizant of the fact that the same consumer protections need to be in place for both HOAs and metro districts.
Great. Thank you, Natasha. Jennifer, please go ahead.
Yeah, and so Natasha, I don't know if this will help with your concerns there, but Representative Judah's bill that was signed last week by the governor eliminates the ability for a district to foreclose due to covenant enforcement or design review penalties or fines. So that's why my comment is that I don't feel like this is applicable anymore because the districts no longer have that power to do any foreclosures of those types of fines.
No,
Right.
and thank you for bringing me up on speed. I have not read it in detail to make sure that it covers, but you seem to be on solid footing, so I'll defer to you. I appreciate that, Jennifer.
Yeah, and it's House Bill 24-1267 in case you want to take a look at it. It's online on that. It was just signed on Friday too, Natasha, so that might be part of it. But we worked with Representative Judah for that bill, for that elimination. So
Great. Thank you, Jennifer. I appreciate that. All right. So our third section was around communications with HOA homeowners regarding association processes and homeowners' rights and responsibilities. Are there additional comments that people would like to make around those those notes in the HOA report and its application to metro districts? And it sounds like we have a little bit of background noise with one of our participants. So if you're not speaking, can you just take a moment and make sure that your line is muted? Any additional comments on I know we talked a little bit of item number 3 with the communications and just the importance of transparency and how that is obviously a best practice and applicable to metro districts as well. But anything else that folks would like to say regarding that section of the HOA report and its relevance to metro districts? Okay, we will go ahead and move on. So the next section, it is fairly dense, but it is generally around making available certain documents to HOA homeowners around governance, policies, rules and regulations, financial statements, reserves, most recent reserve study, records of the executive board's actions to collections or legal actions against a unit owner. And I know we talked a little bit about that again with transparency, making sure that there is that information is available to homeowners and really some consistency around how things are disclosed and shared with homeowners in a really transparent way. Anything else that we'd like to say around that?
I have a question.
Yes, please go ahead.
If we're looking for kind of differences or overlap, right, between the two areas, Brian had mentioned like some sort of like truth disclosure, kind of like maybe a simple format. Do we already have that between the two where it's regardless of whether it's an HOA or a metro district, a homeowner can look at these consistent sections based on topic or subject and say, look, here I've got an HOA, here I've got a metro district, and I could look down and I see, okay, expected costs are debt incurred, obligations, disclosure. How consistent or inconsistent are those between the two as far as format and understanding?
Anybody care to answer that question? Brian, yes, go right ahead.
Yeah, I think they're very different. I mean, for example, in the case of a metro district, because we're a government entity, when we talk about finances, we put together a budget, but the budget doesn't have to be transmitted to the individual homeowners before the budget hearing. And whereas with HOAs, they have to send the budget. Basically, all we have to do is we publish a notice that the budget is available. Now we have an informal meeting where we sort of address homeowner questions regarding the budget, which hasn't been done before. It's just barely begun last year. But once again, there's not the mandatory annual letter that summarizes all the detailed budget items, the proposal for next year, the comparison that is done with HOA. So HOA is much more transparent in terms of its annual budgeting process than the Metro District is, in my opinion. Similarly, the Metro District, files a lot of government documents. Most Metro Districts file audits, not all of them. I mean, there's many that get audit exceptions, especially the developer Metro Districts that are just being begun. But it would be useful, I think, if there was a more disclosure of those kind of items via maybe annual mailings and a management discussion and analysis section. I know we do that in Tollgate Crossing for our annual financials, but that's not required. And so therefore, a lot of this is too dense, I think, for a typical homeowner to understand when it's just posted on the state auditor's website. So I think it's very different from what an HOA has to put together versus what a Metro District has to put together.
Great. And Jennifer, I see your hand was raised. Would you like to chime in?
Yeah, just to add on top of that, which I appreciate Brian's comments and insight and perspective on that as well. I would think one thing that I would like to steer away from are increased mailings just because of the cost. If we could have things posted to the website for people to access those types of things, I'd like to have that considered whenever we make any of these recommendations, just because seeing how much even the cost of mailing for some of the elections is added to districts is just really high. So to the extent that we can post as much of that information as we can to websites, I think that would be a win-win because it's also saving residents some money too. That's all I had to add.
Great. Thank you, Jennifer. Commissioner Odorizio, I see your hand is raised.
Yeah, I guess my question is instead of, and I understand we could go into a lot of detail on the substance, but I'm looking at more form than substance. If we were to create some sort of commonality of form, and the difference may be the content of that, like let's just say it's tabular, it's in a table, and you say, okay, how are you notified about expenditures? Where can you go for more information? All that. If there's some consistency between the two, that might help homeowners be able to understand the difference of the substance that Brian and Jennifer brought up. This will come to you in the mail, or this will come to you is available online. Either way, where do you go? Or where will you get the information? I'm saying take it a step higher and identify common terminology in the categories of what you may put into each field of a disclosure. And so then at the very least, you may say, okay, for the HOA, here's how I get the information. Here's how often I'll get the information. Here's the governing body and where I go to learn more about that to participate. And then the Metro District might have a very similar table, but the content will be different. And then later on, you can always talk about the policy, dive into the details of how we may want certain of the substance to be more in line. But at the very least, you're identifying common categories for the disclosures. And then it's consistent where people can say, okay, at least I understand where to go get information in all those different types of categories.
Great. Thank you, Commissioner. Marianne, I see your hand is raised. Please go ahead. All right. Well, let's go back to there's Marianne. Okay, go ahead.
I've got so many mute things going now. What I was going to say is with regard to the transparency on finances, budgets, or audits for districts, for the districts anyway organized, I think it is, and Jennifer or Brian, correct me if I'm wrong, I think it was January 1, 2000 was the cutoff. So districts organized after that date now have to have annual meetings. And some of the requirements for those annual meetings is to go over your financial information, is to go over your debt, and of course, answer questions that the community has. We had obviously many of those meetings last year for the very first time, and had a good turnout at many of those meetings with people from the community going over the financial statements, going over the questions people had about existing debt and future debt, improvements that are in the ground, and improvements coming in the future. I think the challenge with having similar disclosure documents is that they're so different. Most, as far as I understand, most HOAs do not incur debt at all, and they're not really building anything. They are maintaining improvements that are given to them by other, I'm assuming developers or home builders or some other entity. So it's a whole different process. But I agree that if you're not putting too much detail in it, the notice could be the same to say, this is where you go for the additional information. Here are the websites. You know, here's the state auditor's office. Here's the et cetera. You know, all the places that people who are familiar with these entities know where to go. I mean, I think that is helpful. Trying to plop in specific financial information for HOAs is one thing to try, because they have such a limited scope and limited revenues, and they don't have debt. When you start trying to do it in districts, it can get very complicated and confusing. I think the city of Aurora has come up with a pretty comprehensive disclosure document that they require for districts with service plans approved. I can't remember after what date, Jennifer, maybe you remember. But they've worked hard to get a lot of debt information, mill levy information, calculations on how you determine what your taxes are in that notice. So that could be a reference point for the deep dive on how to disclose for district information. But again, I think disclosure is great. I think the hard part is we want to strike that balance between giving people enough information that they know where to go, as opposed to giving people information that they think is not going to change. Because with districts, there's a lot of dynamic change. And with HOAs, I think they're more static in their financial information.
Thank you, Marianne. Other comments before we move on? All right, fabulous. So our next item is HOA homeowner complaints. And we did discuss this a little bit already, that, you know, there is definitely some potential application to metro districts in terms of having a centralized repository or process for those complaints. Is there additional comments that folks would like to make around that section in the report? And if you're following along, that is on page 24 in the report. Yes, Brian, I see your hand is raised.
Yeah, thank you. I think that the concept of a central repository for homeowner complaints is critical for both metro districts and for HOAs. In fact, it's probably more critical for metro districts than for HOAs, because in many cases, residents of metro districts really have no recourse at all. They have no one to complain to. The AG's office may be the only one, and they typically don't really understand it, so they don't bother to pursue things that they may have jurisdiction of. I've never seen a local district attorney's office. I've never seen DOLA is just a repository. They don't really handle complaints at all. So I think it's necessary, and I think it should be critical that there be some type of a repository that would receive complaints, that would initially screen those complaints to see whether there's anything tangible or not, or basically whether it potentially could have a plausible, actionable claim, or whether it's just something that is outside the jurisdiction of the law, that there's nothing that can be done. And I think there needs to be some kind of a third-party ombudsman that would review those and either refer them to an appropriate government authority if they believe there's a violation of the law, or alternatively send a letter to the homeowner saying, unfortunately, there's nothing we can do. Or perhaps if Representative Story's bill for an independent ethics commission jurisdiction extending to metro districts applies, forward those complaints to the independent ethics commission and ask them to investigate. But I think that there's a lot of actions by certain Metro District boards that that I believe is potentially or probably illegal, that is not being investigated, that is not being looked into, that is not being referred to proper authorities, because there's basically no one to refer it to, and the only way a homeowner can challenge it is through filing a lawsuit, which is difficult, which is expensive, which they're not going to do.
Great. Thank you, Brian. Other comments? Marianne, I see your hand is raised, but it never went down after the last question that you asked. So I'm not sure if you actually have your hand raised or not, but I do see it. All right. Anyone else have comments before we move on to our 6th item? All right. So item number 6, and I do want to just point out it's around 2:46. So we have about 15 minutes remaining, and we do have a little bit that we need to discuss just to wrap things up at the end of this call. But so we may have to run a few minutes over if that is all right with folks. But we'll try to move as efficiently as we can. So that 6th item is around examination of House Bill 22-1139. So again, what are folks' comments on this and anything in this report that is valuable for consideration in our own report? This may be one of those that easily went into the does not apply category, which is fine. All right, we will go ahead and move on to our 7th item, which is the creation of a reserve bill, which we did talk a little bit about, but would anyone like to expand on that conversation? Okay, excellent. So then the 8th item on our list is the creation of an alternative dispute resolution process. And if you're following along, that is on page 28 in the report. Are there comments that folks have on that section of the report and its relationship to metro districts? Okay, I think that's that we're on a roll then. Fabulous. Our 9th item is around licensure of community association managers. And Natasha, I see your hand raised. Is this for the ADR?
Yeah, this was going back to the ADR.
Okay, yep, go right ahead.
And I don't know, I was surprised that everyone was silent, but I think there is especially when so many districts are still developer controlled, or developer tries very hard to keep control of making sure that the process is accessible and people can bring action. So I think ADR is applicable and needs to be part of the metro district concept and structure. So I was surprised to hear silence from the other committee members. I'd love to hear your thoughts.
Additional thoughts on ADR?
How does it differ now? I mean, I guess is there a consistent ADR for the HOAs? Is it just identified as a potential need? Because it's my understanding that as a private creature of contract or covenants, it may not be similar. I mean, it could be very varied from one to the other, whereas you have some very consistent statutory details when it comes to metro districts. And if I'm wrong, feel free to correct me.
Brian, go ahead. Yes, I see your hand raised.
Yeah, I'll address Commissioner O'Dorisio's comment. The Kiowa currently requires HOAs to have one of their mandatory policies in place as to how to deal with dispute resolution and favoring ADR, where the HOA basically the board, if it's not specified in the covenants, would come up with an ADR process to try to resolve this. There is nothing similar that is required, as far as I know, with metro districts, although I think it's a good idea to do so. I think in general, any type of way of simplifying dispute resolution is useful. But because metro districts are government entities, they don't have that similar kind of contractual ADR that would be found in covenants, for example. So that's the difference there. But it's probably a good policy. to at least request, or if not require, metro districts to come up with some type of a policy as to how to deal with dispute resolution.
Thank you, Brian. Marianne, go ahead.
Okay, what I'm thinking is, in the context of homeowners associations and ADR, their disputes are related to covenant enforcement. And I think similarly to the discussion of foreclosing on fees and how that process can work, if we're talking about ADR related to disputes on, did you put up a dog run when you didn't get permission, or is your fence not the right fence for the kind of lot you have, or, those sorts of things. I mean, mediation could probably be more efficient than litigation of those things. But I think there's more complicated issues that are the subject of some of the litigation that has been brought. And I think an alternative dispute resolution process is not reasonable when somebody's challenging the ability of a government to pay on its outstanding debt. I mean, I don't know, Jennifer, if you have any thoughts on that, but I just don't want to leave this discussion with anybody thinking that we're silent on that issue. That would be devastating to the debt issuance process.
Thank you, Marianne. Other comments on that?
I think that's wise. There's a difference between covenant type enforcement versus operational or governance. And I can only imagine if we were forced as an Adams County Commission to have an ADR every time somebody questioned some budgetary expense or policy decision we're making as a county, I'd be in ADR all the time. But I do think there is a difference between that and maybe like code enforcement when it comes. I'm drawing connections to local government, and we do have different processes for code enforcement than we do for like somebody wanting to challenge a budgetary or policy decision at my level. So I do think that it's a good it's a good distinction between the government and policy side versus the I guess kind of code enforcement slash covenant enforcement in the neighborhood.
Thank you, Commissioner. Marianne, I see your hand is still raised, but I think it might be just raised from the previous comment you had. So we will go ahead and move on to licensure of community association managers. So any comments on that section, or areas where it might intersect with Metro District conversations? That one did appear to be fairly specific to HOAs, but any other comments on that? Yes, Brian, go ahead.
Just briefly, I just want to clarify that I don't think licensing of managers is as necessary in metro districts as it is in HOAs, because metro districts, because of the legal requirements of metro districts, there typically are professional accountants and professional active involvement by legal representatives, attorneys in the case of metro districts that you don't often see in the case of HOAs. Usually the manager handles most of the accounting and the finances. So it's not as important for metro districts, but there are some items I think that it would be useful to have at least some type of, I wouldn't necessarily say licensing, I don't think that's necessary, but perhaps some type of training for metro district managers on the differences between for example, the differences between legal requirements of metro districts and HOAs. I know some of our managers have been very experienced in that, but there's other managers that are not quite as experienced, and they typically carry over from the HOA field a lot of their experience, which is inapplicable to metro districts.
Thank you, Brian. Jennifer, yes, go ahead.
Yeah, and I think on that, maybe that hair can be split a little bit to be for those that are maybe managing both of them, or don't exclusively manage metro districts or something like that. Because I do think that there are some that overlap that are HOA focused, but then kind of dabble, if you will, in some districts, maybe vice versa. And so to the extent that there are that and they don't have a specialization in it, then there can be some accreditation or classes or something like that to help draw those distinctions. But I do agree with Brian that there is a more heavy focus of legal and accounting, which are often different firms as well. So you also have the checks and balances there that you don't see often with HOAs. So.
Thank you, Jennifer. Commissioner O'Dorisio, please go ahead.
I think if there is a commonality between the two, it might be that we could identify resources to help with that type of training and best practices rather than a mandate. And so just like we all may have different professional associations, that if we could have, like, maybe it's the state DOLA or whatever, you know, just the encouragement could be to lean in on management of communities, whether that be in one context or the other, and identify where those overlaps are. And it could just be general skills, but I would not want that as a mandate, maybe more as just a resource from the bottom up to encourage best practices and competent skill-based training.
Great. Thanks you, Commissioner. And Marianne, I see your hand went back up. Go ahead. Okay. Marianne, I think you put your hand down, so I'll assume you're good. Okay.
Oh, sorry. I was just saying, Special District Association is that resource for people, and I think I agree to encourage people to become members who are managers, accountants, and we do encourage that, and I'm sure all the practitioners do, because the more access board members can take of the Special District Association training, conferences, et cetera, and those who are supporting districts, the more educated they become. I think it's similar to CML and CCI in that regard.
Right. Thank you, Marianne. I appreciate that. All right. Anything further on this before we move on to our last section of the HOA report?
It's kind of a side comment, but what I would say is during the course of our different meetings, the question has come up, how do we educate county commissioners and city council members? In talking with Ann Terry, she did make the point to me that city council members and county commissioners can also become members of Special District Association, and they do cut fee breaks to those electeds who want to take advantage of that education process and their resources, their online resources, et cetera. So I'm just kind of putting that out there to anybody who wants to encourage their city council members and county commissioners to take advantage of that so they can become more educated on metro districts. Thank you.
Great. Thank you, Marianne. Appreciate that. All right. Our last section of this HOA report is on the voter reform bill. And we touched upon that briefly at the beginning of our call, but is there any additional comments that we want to make on that section of the HOA report or clarifications on what was discussed at the top of the meeting on that particular section? And again, if you're looking for that in the report, it is on page 30. So it's the very last section before we get to the appendices. All right. I'm not seeing any hands go up, so give it one more second to see if anyone has comments on that. Yes, Brian, go ahead.
Yeah, I just want to follow up. I thought it was clear, maybe it wasn't, but my understanding is this section does not apply at all because, as I say, the metro districts several years ago, the legislature created a local government election code that is very specific. It follows a lot of the public elections in the state of Colorado, and therefore I think that deals with substantially all the issues that would be present in this voter reform bill, I believe.
Great. All right. Any final comments on this before we wrap up this section of the agenda? All right. Well, I appreciate your patience as we pivoted our approach a little bit midstream there, but I think we were able to get through everything fairly efficiently. And you really did bring up quite a few of the overlapping themes that I saw in the two reports. Those topics around education, transparency, making sure that homeowners have access to information and are educated about what is available to them. Those are all really good themes that apply to multiple types of environments, not just not just metro districts, but also HOAs. So I think you all did a fabulous job dissecting that and bringing those issues to light. So I appreciate that. So moving on to the very last portion of our agenda here, and we will try to move this along so that we get you out of here on time. But since this is our very last meeting of this task force, we did want to just provide some wrap-up summaries for everyone, since we have not spoken to you since February 26th. So you'll recall that that our session on the 26th was our public testimony and task force discussion. So I wanted to just walk us through really what we've accomplished since our first meeting on December 5th. So we met for the very first time on December 5th, and that was our opportunity as a facilitation team to just learn a little bit more about each of you individually, but also clarify the legislative mandates and our corresponding scope of work. We also wanted to get your feedback on our proposed approach to how we were going to structure our meetings. The scope of work was crafted specifically to the requirements that were in the legislation, which were to examine issues confronting Metropolitan District homeowners' rights and prepare a final report of its findings and conclusions regarding matters the task force examines. So, actually, sorry, I just gotta get my slide to advance. There we go. So unlike the HOA task force, we noted in that first meeting that the Metro District task force was not asked to achieve consensus or produce specific recommendations. And this distinction was notable, and it informed our approach. We designed a process to prioritize a thorough examination of the issues that are confronting homeowners' rights, and also ensure an equitable input from each of you as task force members. Our meeting content, while the legislation did not direct us to produce specific recommendations, it was very prescriptive on the topics that we were required to address. And so you can see here we have our 5 topics plus 1 action item that was detailed in the legislation. We had our tax levying authority and practices, foreclosure, our communications topics similar to HOA, governance policies, including voting and elections, and the method by which a Metro District could transition into a common interest community. And then that last action item that was on there was also today, and that was the review of the HOA report. So we went over that in our first meeting. And then we also spent a considerable amount of time at that first meeting hearing from all of you. You provided us with fabulous input on the topics and some of the more specific subtopics that you felt needed to be addressed. And that was frankly invaluable to us as a team as we planned out our meetings to ensure that we covered all of the mandated topics, but that we were also providing the right resources and structure to support our outcomes. We also sought your input on that first meeting on speakers that could provide that additional educational content to help support our discussion and make sure that we were covering all of those mandated topics with the right education. Our task force members provided us with a number of suggestions at this first meeting, and we also continue to get your suggestions at subsequent meetings, but also in some meetings from DORA. In total, we received about 20 recommendations for expert speakers from all of you, which we really, really appreciated. And with that, your input, we established the following schedule of meetings that we discussed at that first session. Our December 18th meeting was on the communications with homeowners about Metro District processes and homeowners' rights and responsibilities. You'll notice here that we also, we had our foreclosure practices on January 8th, as well as transitioning a Metro District to a common interest community. Originally, we had scheduled for that January 22nd meeting, the governance, including voting and elections. February 5th, our tax levying authority and practices, and then our February 26th meeting. Now, you'll see a little red asterisk next to that on January 8th meeting. And you'll notice that we also did not include a session in our initial schedule of public testimony. DORA had provided an excellent platform for members of the public to provide that written comment, but the legislation didn't require public testimony, and it wasn't something that was necessarily brought up in that first meeting. However, this is where all of you really stepped up as leaders. And in that third meeting on January 8th, that is where we had the opportunity to check in with you on our process and seek your input on some possible improvements. And the task force felt strongly that we should have an opportunity for public testimony. So we pivoted the plan. And we revised our schedule so that we could accommodate public testimony, which we did on February 26th. And then we added this final meeting today where we could review the HOA task force. And we were very intentional on that February 26th meeting because we knew it was important to get as much public comment as possible. We were able to extend that meeting time to a longer duration, and everyone who signed up to speak at that public testimony was given the opportunity to do so. So going back to our first slide on how we've managed through all of our mandated topics from the legislation, you'll see we've got, we covered our tax levying meeting content at the February 5th meeting, foreclosure practices at our January 8th meeting, our communications topics at the December 18th meeting, our governance policies, including voting and elections at our January 22nd. We discussed that transition of metro districts to Kiowas and what that might look like, and that was at our January 8th meeting. And then, of course, today we had our review of our task force, of the HOA task force's report. And then finally, the bonus, which I like to check things off because it gives me a sense of accomplishment. But we did have public testimony on February 26th, which was our response to the feedback that we had received from all of you. So I think it's really nice when you have your final meeting to be able to reflect on the work that you've done as a group, but also just go back and double check that we have indeed fulfilled all of our legislative mandates that were required of this task force. So that brings us to the final agenda item of our day, which is to give you just a quick overview of some of the feedback that we received from task force members in response to our interim report. Now, again, per the enabling legislation, we were required as a team to produce an interim report of this task force to DORA by March 1st. DORA then provided the interim report to all of you on Monday, March 4th, and we gave you until March 15th to provide your input. We received several constructive clarifications and suggested edits from the task force, and right now our report writer is incorporating this feedback into the final report. But since we did have the opportunity today, we thought we would just give you a quick overview of just a summary of some of the feedback that we received for that interim report. We see several comments from folks on just correcting some factual inaccuracies or inconsistencies with the report, which we definitely appreciated. There were a number of requests for further clarification of content to make sure that we were more accurately and completely reflecting task force discussions. And then there were a few cases where members wanted to make sure that their specific comments were reflected differently or perhaps summarized in a slightly different way. We had some requests that the report incorporate some additional content, such as the materials that were provided in advance with those educational materials that were part of the pre-read. So we wanted to, we'll try to incorporate that as well. And then we also just had some questions throughout the report on some statements within the report. Sometimes those statements were presented as fact when they really were more of opinion, but also vice versa, where they were expressed as opinion and not fact. So we were working through some of those comments as well to make sure that it is accurate and reflects your intention. So that brings us to, and as we are over time, we do want to move right on to those final remarks. So what are our next steps? So right now, between now and the end of or early mid-May, this facilitation team is going to be incorporating just a few more edits as a result of our work together. We are going to complete the section of the report that inventoried that public comment that we received on February 26th, because as you recall, the timing of that and when the interim report had to be released was pretty tight. So we do need to include that in the final report. We're also going to be continuing to incorporate that feedback that we received from all of you as task force members, so that all of those edits are included into that final report. And then our last step is going to be completing that section of the report from today and summarizing that discussion and making sure that that piece of our reflection on the HOA report is included in our final report. Our goal is to have this, again, all of these pieces wrapped up by mid-May so that we have ample time to get this over to DORA, because the final report is due to DORA on June 15th. So with that, I wanted to just see if there's anything else that folks would like to bring up today before we wrap up. Certainly happy to take any questions, comments, but I want to also make sure we save a little time for thank you. So any comments from folks before we move on? Yes, Brian, go right ahead.
I apologize for seeming to dominate today's, but a lot of people aren't commenting. So I want to make sure this got out. First of all, I'm concerned, very concerned, that one of the legislative mandates is that the final report is supposed to provide the task force's, quote, findings and conclusions. And that's a quote from 23-1105 on these topics. The version of the interim report that I saw was not close to that at all. It was basically just a transcription almost of some person's view of what they thought they heard at these various meetings, and certain excerpts of quotes here and there. I don't think that's consistent with what the legislature requested that we do. So I guess the concerns I have are, number one, how are we going to decide as a task force what our findings and conclusions are? I will say that I did like the HOA's task force's Appendix A and Appendix B, where the individual task force members had the opportunities to indicate their particular priorities. And then there was a procedure where each of these priorities, once identified, could be voted on either up or down by the individual task force members. And I'd like to see the same thing in our final report in Appendix A and Appendix B, similar to that. The other item is, it seems that this the report was crafted by someone. I don't know if it's the facilitators or if it was DORA staff or whatever, and didn't really give the opportunity for individual task force members to put together their particular views, their particular findings, or their particular proposed findings, similar to what I've seen in other task forces. Other task force reports I've seen typically have that. They typically have the ability of minority reports to be submitted, or proposals that maybe the entire task force disagreed with, that they nonetheless found it important to inform the legislators. And so I would like the opportunity that we have the opportunity to review this next draft or close to final report. And while we may not change it, that I think we should, at least as task force members, be provided a couple of weeks at least before June 15th to add our own position statement, minority report, whatever, that may inform the legislature on some of the items that the task force report may not have included. So those would be my views, that we include a Appendix A and Appendix B, similar to what the HOA task force did, and that we be allowed the opportunity to review it one final time and present some type of individual task force members' opinions or minority reports on certain items.
Great, thank you, Brian. I do want to just, I do have a few things I can speak to on that, but I want to give other folks a chance to comment. And so, Commissioner Odoricio, I see your hand raised.
Well, why don't I let you go ahead and speak to those things, and then I can questions if they're not.
Okay, I will do my best. So, certainly I can only speak to our facilitation team, and I don't want to speak on behalf of Marcia. But when it comes to how we structured our scope of work for DORA, it was structured very intentionally to the legislation, which for the HOA report was very specific in calling for recommendations and making sure that that was very clear that the task force had to have recommendations. However, it was explicitly left out of the Metro District Task Force legislation. And so I know we were getting our guidance from DORA in terms of what the appropriate scope of work would be for this for producing this report, understanding that there was a difference between how what was required of HOA versus Metro districts. But again, I don't want to speak for DORA on this, because I know that they were also, they were developing a scope based on their interpretations of the legislation as well. So, Marcia, Dora, team, I don't know if you'd like to comment on that, but certainly want to give you that opportunity.
So to try to accommodate what Brian is suggesting, would you guys like to have the opportunity to submit your own kind of suggestions the way that we did with Appendix A and Appendix B? Realizing that we're not going to have a follow-up meeting for you to attach your name to, but if you guys had your own individual thoughts that could be included as an appendix, would that address your concerns? Yes, okay. And I will tell you that the two task forces ran slightly differently, because the HOA task force, in addition to meeting the statutory mandate, looked at a bunch of different additional things, which kind of made it a little challenging on that end. Ultimately, the goal is to make sure that we get this report completed by the deadline, and we learned some things with the HOA report, some additional things that are added in at the department level that we hadn't expected. So as far as sharing a copy of the report with you in draft form before June 15th, I just need to see where we're at as far as the actual report getting done and getting it through the different layers of vetting. I don't want to promise you something and then not be able to fulfill it.
Thank you, Marcia. Commissioner O'Dorisio, did you have comments?
I do indeed. I might have a little bit of a different take than Brian on this one, because the way I look at it, we could, I think that by having it be more about, I thought this group was extremely transparent and inclusive. I thought you were also very comprehensive in covering a lot of different topics and listening to different perspectives. I think if anything, the value of this group was to be able to document some of the facts and perspectives that are out there. And I actually appreciated the fact that we didn't have to try to hammer out recommendations or conclusions we would disagree with. And in fact, what I look at this is really the source for future work. And that means that this source of future work means that Jennifer Tanaka might take some of this and cite some of the information identified differently than Brian might, but it still comes from a single source of effort done to collect perspectives, data, and information. I think that's the value here. To be honest with you, I think you have more flexibility, Brian, to be able to take some of that data and what you see here and then propose some of your solutions. Even I have some ideas too that I would be happy to share with someone afterwards, but I got to tell you, I look at this as the beginning of next steps. And so I could see us very easily saying, okay, who's interested in diving into the discussion of education? Maybe we get somebody from the Special District Association and CCI and CML and a few of those, maybe even Property Management Association, to participate in a discussion on education. Maybe separately, we have a discussion on alternative dispute resolution topics. And it could cover everything or not, but I think you have more flexibility by not being tied down to try to get all on the same island here. And then, I'm offering right now, I've got some ideas on how we can use local government powers that already exist to do more. And if anyone who's interested, feel free to come talk to me afterwards. But what I worry about is the scope creep of expanding this report to try to get us into all on the same page on stuff. I think we all have the ability to do this on our own, and it might even take away from the important work that was done if we turned it into too much of I think we've done well without making it very confrontational or conflicting. And I think we've done a great job of gathering a lot of really good source material to be used for the next steps, is all I'm saying.
Thank you, Commissioner. Jennifer, I saw your hand up next.
Yeah, and I would agree more with Commissioner O'Dorisio on that as well. What I want to avoid is a battle of who has the most time to put together a comprehensive thesis of their opinion and having a battle of that in the appendices. I feel like we have come together to hear different perspectives and voice ideas. I did like in the HOA report how it has the chart of kind of an idea and who agreed with it or who didn't. I think something like that to me would be more beneficial to say, okay, we had the majority of people that agreed with this idea. And, maybe this was a one-off idea that one person thought was a great idea and the others didn't really get on board, but it's still in the report to share with people because it doesn't mean that it's not a good idea. It's just that we all had a different thought at the moment. I feel like that might be a little bit better than us opening up a task for us to go write our own kind of dissenting opinion or opinion in support thereof the final report. But I think it would be a little bit more direct and helpful for those reading it.
Thank you, Jennifer. Natasha, I see your hand raised.
Yeah, I'll be a little bit more of the dissenting one, and let me, sorry, get back in here. The process was interesting to me. I mean, the agenda was set by the legislator. I appreciate that. I think my frustration is there was a reason this was formed, and I think we heard it when we heard from the public. And the really big issues that were raised, and again, we did have a sign-up process, but unlike in the legislature where you can sign up the day of, I thought it was very arbitrary to cut people off. A lot of people didn't know we were allowing public comment. I think a lot of voices may have gotten missed, but the voices that did come on were strong. And I think the thing that stood out more than anything were the abuse of the master servant structure. The report doesn't even really address cabs or any regulations there that in some cases de facto take away control from homeowners forever. So, and not that I would have the bandwidth to do a minority report, but I hear what Brian's saying. And I think as a task force, I agree with Commissioner Ordoricio's that these are the beginning of the next steps. But I think we needed to reflect the reality that for so many homeowners, this is at a crisis point. And, one of my comments was that on the edits was we took some things from industry as fact versus an opinion, the Henderson report perspective. And I think when we say we had speakers that were diverse, I actually take exception to that. I thought primarily we heard from industry, with really one exception. So I don't know how we can have homeowners at a point of crisis logging on with a good level of anger and frustration and gloss that over, that there are issues that have not been addressed. So I somewhat understand the need for a minority report or to address, and maybe it is, Commissioner Ordoricio, the beginning of next steps. But what I heard loud and clear was, what came out in that homeowner meeting, it was very definitive, it was very consistent.
Great. Thank you, Natasha. Appreciate that. I might put this back to our DORA team in terms of some next steps that you feel comfortable with at this point. I know that our scope of work as a team was developed with a particular outcome in mind, which was a report that just summarized the discussion and the differing perspectives, not necessarily recommendations or firm conclusions or a minority report, but understanding that your team at DORA has to manage a mandatory deadline of June 15th and some of the nuances that come with that. So I just defer to you on how you'd like to direct the next steps for this task force.
Would you mind if we put our heads together kind of at the division level and see what we can come up with, and then we'll just reach out to the task force with our thoughts?
Absolutely. Commissioner Ordoricio, I saw your hand up. Did you mean to say something?
No, I think that's a smart idea that Marcia brought up. I think you guys have a better grasp on some of the details of how to deal with this operationally. You have a deadline, and that deadline needs to be met. And I actually think you've accomplished a lot of what needs to be done in that deadline with the draft and with what we're closing up with today. My question would be are we now allowed to start talking to each other about that second step? Let us know when that green light hits so we can start collaborating and having discussions about some of the stuff. Like, I want to hear what some of Brian's ideas are, and I wouldn't mind sharing some of mine and have, folks from industry here, like being able to say, hey, what do you think of this? I think if we could try to find, I just need to know when that green light is, because I think that there's some real opportunities for next steps. And it may be more organic than organized and formal anyway. I think that's where you're going to get a lot of solutions. based on this really good data gathering and information gathering that we have here.
Great. Thank you, Commissioner. With that, I know we are quite a bit over time, so apologize for our late ending point, but I just want to end our time today with just a few thank yous. I do want to thank the DORA team. You all have been a wonderful partner in this process, and we appreciate all the hard work you've done behind the scenes on this process. I also want to just thank the rest of my Elevate Momentum team. I know I've been the face on camera, but I actually am just one of a team of 4 really extraordinary professionals that have been supporting your efforts for these last couple of months and putting in a considerable amount of time. So, so definitely not just me. There's other folks that are have done a wonderful job in supporting all of you. Also, just want to acknowledge all the speakers that were joining us throughout these last couple of months. It is a lot of time and preparation to provide educational content, and so I just want to acknowledge all of those efforts, and then also acknowledge the public that showed up on February 26th and provided their personal testimony. That was a very important piece of this process, and something that I know that was very important to task force members. And then finally, just want to thank all of you as task force members for your commitment to this process. We know that these policy conversations are not easy, and they can sometimes have frustrations, which certainly is part of the process. And sometimes people don't even want to participate because of that frustration. But you all answered the call and were valuable, and everyone contributed so well to this process, and really just want to make sure that you receive the appreciation and thanks that you deserve as a task force for being part of this process and just educating and informing next steps on this really important topic. So with that, any final comments from Task Force Chair Marcia? Anything you want to say before we wrap up?
I just wanted to echo the thank you to all of you for your time and efforts with this project. I think the end product hopefully is something that the legislature will be able to move forward and use positively. But again, just thank you all.
Great. All right. Thank you. We can all wrap up now.